What is the international patent process? This video is going to give you all you need to know about filing patents outside of the United States and give the information on your different options for filing in foreign countries. So if you're new here, my name is Dylan Adams. I'm a patent attorney and author of the best-selling book, Patents Demystified, which is an insider's guide to protecting ideas and inventions used by inventors, entrepreneurs, and startups worldwide, including top universities like Harvard, Stanford, and MIT. You also might recognize me from my appearance on CNBC's hit show, The Profit, with Marcus Lemonis. So this channel is all about giving you the insider information about how I help my clients, whether they be Fortune 100 companies, startups, or Shark Tank companies, protect their ideas and inventions. So hit the subscribe button and the little bell icon so you get notifications of when new videos come out. All right, let's get right into it. So the first thing I want to point out when it comes to the international patent process is there's no such thing as an international patent. And people throw that term around and it leads people to think that you have a United States patent and then there can be this patent that covers the rest of the world or covers a lot of different jurisdictions, and that's just not the case. Patents are jurisdiction by jurisdiction. And so for instance, you could have a United States patent and you can stop people from making, using, selling, offering to sell the claimed invention within the bounds of the United States or importing into the United States, but you would have to have a patent in any specific other country to stop people from doing stuff there. So for instance, if you want to stop activity in Canada, you'd have to have a Canadian patent. If you want to stop activity going on in Germany, you would need a German patent. If you want to stop stuff going on in China, you would need a Chinese patent, etc., etc. So patents in international countries are jurisdiction by jurisdiction. So when people talk about an international patent, what people are a lot of times referring to is there is an international patent application called a PCT application, which covers just about any jurisdiction and most of the important jurisdictions. And I'll talk about PCT applications in a moment. So that's the important thing to note right off the bat is patents are jurisdiction by jurisdiction. There's not some wide blanket international patent. Okay, so there are two main ways that you're going to be able to file patent applications or routes that you're going to be able to file foreign patent applications. And when I'm talking about foreign, keep in mind I'm talking about outside the US. So I'm a US patent attorney. I work with foreign patent applications all the time. And so when we talk about foreign, it's sort of non-US patent applications. So definitely keep that in mind. So the two ways, one is going to be by filing that PCT application, which I talked about, or you can do direct national applications. So with direct national applications, you have to file those directly in each country, and you have to do that. That's sort of your first step. Okay, it's very, very expensive to do that. Filing fees are really expensive in each country, and most countries require what are called annuities to keep the application pending. And there are maintenance fees in the U.S. once the application is issued. A lot of foreign countries require yearly annuities to keep the application pending, in addition to annuities once the application is issued. Filing fees can be really expensive in each jurisdiction, varies by jurisdiction to jurisdiction, and also, kind of on the currency differences. But then also there can be translations. Some countries require translations, which can be expensive. So if you're going to be starting the process with direct national applications, it's a pretty expensive way to go. So typically, the way that we do it for most clients is we file what's called a PCT application. So the PCT application, PCT stands for Paris Cooperation Treaty, and it's really an international treaty that just about every country has with each other that says, hey, if you file this unified PCT application, it's a placeholder that then gives you time to then file national phase applications in each jurisdiction. So a good way to think of it, it's almost like a provisional patent application for international applications. So you file the PCT application, and that's going to give you, typically it's going to be 18 months from when you file the PCT application, or really it's going to be 30 months from your original priority date. And I'll get into the original priority date and what we typically do to start the patent process and then do foreign. So it's going to be typically about 30 months from your original priority date. Some countries are 31 months, but just assume that it's going to be 30 months from your original priority date, because that's, it's better to kind of start the process early as possible, because what a lot of people don't realize is that, hey, you can't just file a national phase application immediately. Sometimes you have to, get all these notarizations, you have to get translations, and sometimes it can take weeks, if not months, to actually file in certain foreign jurisdictions. But I kind of digress. So let's kind of talk about the PCT application and what countries you can file in, and sort of the timeline for that. So the PCT covers just about every important country. There are, probably a good example of one that isn't covered is Taiwan, and it's because of sort of the political issues with China. Taiwan is not covered in the PCT. So if you're going to go into Taiwan, if you're going in at the foreign deadline, you have to go in directly. You can't file a PCT application, wait 18 months or 30 months from your original filing date, and go into national phase countries. And so let me get into the way we typically do the process with foreign, and why I keep on saying 18 or 30 months. So what we typically do is we file a provisional patent application, and that's the best way, especially for startups and small companies, to start the patent process. A provisional patent application is just a placeholder. You file it, it waits in line at the United States Patent and Trademark Office, and automatically expires after 1 year. That term cannot be extended. So at the end of that year, you have to file the United States non-provisional patent application to be able to claim priority back to the provisional application. That being, to get the priority of the filing date of the provisional application, you have to file the non-provisional within the year that the provisional is filed. So with foreign applications, you have a year from your first priority date to file foreign applications. So the deadline to file your foreign applications is going to be a year from the provisional, just like the US non-provisional is. So typically, what we'll do is we file the provisional patent application, and then right around the year anniversary, we'll file the US non-provisional, and we will file a PCT application, which is going to cover folks in just about every jurisdiction that's going to be important, except for Taiwan. And for instance, I work with a lot of folks who do things with chip manufacturing or software stuff, and a lot of times it makes sense to file in Taiwan as well for those folks. Not for every company, but what we'll do then is we'll file the US non-provisional, we'll file the PCT application, and then we'll also file direct national phase in Taiwan. That's a pretty common thing. So like I said, that's why I keep on saying it's 18 months from when you file the PCT application. So it's 12 months from the provisional to the PCT application, and then it's 18 months from when you file the PCT application to then when you have to file the national phase applications. That being a total of 30 months from when you filed the provisional. So that's why I kept on saying it's a total of 30 months. And so yeah, it's a long time, and that's a positive thing. You kind of want to delay the time that you're having to spend all this money on foreign applications. Doing a PCT application, the filing fees, they can be upwards of $3,000. So the total cost of filing a PCT application can, a lot of times be $5,000 or so. They're not inexpensive, but having that additional 18 months can be really, really important, because filing national phase applications, it's one of the biggest mistakes I see startups making, is over investing in foreign protection and doing so too early. Because to give you just a general ballpark, assume it's going to take, it's going to be $25,000 over time per jurisdiction in English-speaking countries, or it's going to be $35,000 over time in non-English speaking countries. And that's going to be because of translation and things like that, which is going to increase costs. Depends on the jurisdiction. Sometimes filing fees can be lower and attorney costs are going to be lower in some jurisdictions, but that's just a general good ballpark. I mean, it's a lot of money to spend, so you really want to know whether or not it makes sense to actually file in those foreign jurisdictions. And having that extra 18 months from the PCT application can be a huge lifesaver of folks, and it can make the difference between wasting money and or then maybe potentially not filing foreign patent application and losing out on good investors or good partnerships with folks because they haven't preserved foreign rights. And what happens a lot of times is in the life cycle of startups is that, you know, that 30 months from when they file the provisional application, that's right when they're starting to figure out foreign markets, right when they're starting to get partnerships with folks, you know, who actually have penetration in that market, and right when they're starting to get investors who may really care about certain foreign jurisdictions. So having that 30 months from the provisional that you get in addition to, you know, by filing the PCT application, that is really, really important, because it gives you more time to figure out, hey, you know, what jurisdictions are we actually going to be working in? What jurisdiction do our investors really care about? What's the market size in some of these jurisdictions? And, you know, given the cost of what, you know, patents are, to file there and to get, you know, through examination, and then for enforcement, is it really worth it given the market size and the likelihood we're even going to have partnerships there? You know, I mean, the big mistake I see people do is, well, we know that we're going to have partnerships in China. It's going to be important, and we want to file in Europe, and you know, they file all these foreign patent applications, and it is really difficult for people to let those things go, and they throw good money after bad. And I've, like, no joke, I've seen startups tanked because they just over-invest in foreign assets. So definitely don't make that mistake. File a PCT application, and, you know, leave as much time as possible so you can make decisions about foreign applications. And one thing I want to mention too is that, so it is jurisdiction by jurisdiction, but there are some regional patent offices which you can start the patent process, and it'll potentially then allow you to cover multiple jurisdictions. So there's the EPO, which is the European Patent Office, covers, you know, pretty much any EPO member country, which is most of Europe and associated countries. There is a Eurasian Patent Office, which covers a lot of sort of Russian and sort of Soviet bloc countries. And there's actually a unified African patent office, which allows you to get into a lot of African countries. So the way that works is, so for instance, with the EPO, and I do this a lot, this is a very common thing we do with clients, is we file a patent application at the EPO, and we'll do that, you know, the EPO is, you know, that's actually, you know, going to be 31 months after the original filing date of the provisional. So we'll file the EPO application, and it goes through the examination process. There's only one examination, but once the application is granted, you then have to validate in each specific country that you want to have an issued patent in. You have to decide at the time of grant. And of course, you know, each country is going to want grant fees, and so it can be absurdly expensive. Very rarely do we validate in every European country. A lot of times, you know, at that point, people will know, hey, you know, we have partnerships in France, and we have partnerships in Britain and in Germany, and we want to validate in these countries. But, you know, all European countries, it makes no sense to validate in all of them. It's absurdly expensive, and especially some countries, you know, some of the smaller countries with small markets can be really expensive to validate the patents in, whereas other ones with, you know, larger markets can be fairly inexpensive. And so that's something that is really variable as well. So that's kind of the guide to the foreign patent process. I'd love to hear your comments down below. Let me know, have you ever filed foreign patent applications? Do you have any issued foreign patents? Have you been thinking about foreign patents? Do you think that it's worthwhile for your business, or do you think it's completely worthless for your business? Because for some businesses, it makes a lot of sense. For others, it makes absolutely no sense to file foreign patent assets. Let me know down in the comments. Love to hear your thoughts. Also, if you have any ideas for future patent videos, love to hear those as well. And if you want more insider content on patents and startups, click the subscribe button and hit the little bell icon so you get notifications of when new videos come out. And if you got any value out of this video, give it a like. I'd really appreciate it. It helps support the channel, and lets me know that I should be producing more of these videos, and the YouTube algorithm loves it. So thanks again for watching. Really appreciate it, and we'll see you again in the next video. Thanks.